Welcome to this episode of Term Talk, the Federal Judicial Center's video podcast discussing this term's Supreme Court opinions that are likely to be most consequential for the lower courts. I'm Beth Wiggins, the Director of the Research Division at the Federal Judicial Center. For about the next 15 minutes, we'll discuss the administrative law cases decided this term. I'm joined by Erwin Chemerinsky, Dean and Jesse H. Choper, Distinguished Professor at the University of California, Berkeley Law School, and Tara Grove, Professor and Vinson and Elkins Chair in Law at the University of Texas Austin School of Law. Welcome. It's nice to see you both. The first case involves a law that requires the F.C.C. to help communities gain access to broadband. Tara, to help us understand this case, can you explain the Non-delegation Doctrine to us?
Happy to do so. So the idea is that all legislative power granted by the Constitution is vested in Congress, and so Congress should make legislation and not let other entities do it. But of course, in order to do anything, Congress needs the assistance of the executive branch as well as the judicial branch. So it's really hard for anybody to say that something that Congress asks another entity to do is somehow an unconstitutional delegation. And in fact, the non-delegation doctrine has had only one so-called good year in the United States Supreme Court. In 1935, the Supreme Court struck down two statutes on the ground that they constituted an unconstitutional delegation of legislative power. Ever since then, the Supreme Court has rejected every single non-delegation challenge that has come before it. And the standard now is that every statute must provide an intelligible principle for agencies to follow. What's an intelligible principle? Well, it's pretty broad. The Supreme Court has upheld statutes that say to the Federal Communications Commission, you can regulate broadcast licensing in, quote, the public interest and to help as convenience or necessity require. It has upheld delegations as long as they are fair and equitable. So the Supreme Court has allowed Congress to delegate a lot to agencies. And why would that be? Well, not only does Congress need the help of other parts of the federal government, but it's also quite helpful to delegate to agencies. Why does the Environmental Protection Agency handle environmental issues? Why does the Federal Communications Commission handle issues related to communications? It's because agencies have expertise in this area. Agencies can also often act more efficiently, more effectively than Congress alone. And for the federal government as a whole to serve the citizenry, it's extremely helpful for Congress to delegate to agencies. Now, for a long time, this was not a controversial doctrine. Justice Scalia said years ago that it was impossible for courts to police delegations from Congress because Congress had to delegate to some degree, and it was impossible for a court to come up with a standard to say that any delegation was bad. But in 2019, Justice Gorsuch wrote a dissenting opinion in a case called Gundy versus the United States that revived the non-delegation doctrine at the United States Supreme Court. Justice Gorsuch said, when something is a really big deal, a major issue, it has to be decided by Congress, at least if it is in the domestic sphere. And ever since that 2019 decision, more litigants have brought non-delegation challenges, and the idea is that this issue is likely to come up again.
So, Erwin, can you take us through the facts in the instant case, Consumer Research?
It involves the Telecommunication Act of 1996, and it requires the Federal Communication Commission Act to make broadband access available, especially with regard to rural areas and schools. The Federal Communication Commission created the Universal Service Fund to collect revenue for this. In fact, if everyone looks at their phone bill, they'll see they get a charge for the Universal Service Fund. And the Federal Communication Commission created a private company to administer the Universal Service Fund. Consumer Research brought a challenge to this, and a year ago, the United States Court of Appeals for the Fifth Circuit, in an en banc decision, found that the combination of the delegation and the subdelegation made it unconstitutional. And that's what came to the Supreme Court and the Supreme Court 6-3 reversed the Fifth Circuit and it upheld the federal statute and the Federal Communications Commission's so-called subdelegation.
Mm-hmm. So Tara, can you tell us about the analysis and how they got there?
So Justice Kagan reminded everyone that the standard is whether Congress has provided an intelligible principle. And she put some meat on the bones of this idea of an intelligible principle. She said if Congress is delegating really broad authority, it does need to tell agencies a little bit more about what they're supposed to do, whereas if Congress is delegating something really, really small, Congress needs to say less. But the standard is the same, intelligible principle. And the court held in this case, yes, there was indeed an intelligible principle. So the whole program is designed to provide universal services for lots of folks. And Justice Kagan said, okay, so Congress said you need to have sufficient funds. Well, sufficient means clearly enough to provide those services, but not way more than that. And Justice Kagan gives just a wonderful example to illustrate this point. She said, if you told a friend to order a sufficient amount of food for 5 people, and 500 boxes of pizza showed up at your house, you would not think he had followed instructions, right? And so she's saying that the term sufficient actually does tell the agency quite a bit. At the same time, the statute makes very clear what the services are for, and that's to serve people in rural areas who have difficulty getting access.
Okay. So, Erwin, what did the dissent say?
The dissent says that this involves the raising of revenue. Justice Gorsuch writes for the dissent, and he doesn't focus on what the Fifth Circuit had talked about, the delegation and subdelegation. He focuses instead and says, if there is any power that Congress shouldn't be able to delegate, it's that which looks like taxes, raising revenue. And he says that's what's involved here with the Universal Service Fund.
Okay, so what's important for the lower courts to understand about the case?
I think it is important, as Tara says, that the Supreme Court reaffirms the intelligible principle doctrine. The court says that there can be delegations of power so long as there is a, quote, intelligible principle. But also, as Tara says, the court hasn't really defined what's an intelligible principle, and there's going to still be many challenges to other federal statutes on non-delegation grounds, and so I think that this isn't an issue that's going to go away.
Okay. Tara, anything to add there?
I agree with that. I do think it's important that Justice Kagan's opinion for the court says that tax statutes are not subject to a different standard, despite what the dissenting opinion said. And so that at least provides some clarity for lower courts. But this is one of the hottest issues right now in the world of administrative law, and I expect many, many statutes in the future will be challenged, and we'll see a lot more litigation in this area.
Okay. Well, let's move on to the Appointments Clause. Erwin, over the past decade, there's been increased litigation challenging congressional authority under the Appointments Clause. Can you sort of take us through the issues that have arisen?
Sure. Article 2 of the Constitution says that the President shall appoint ambassadors, Supreme Court justices, and officers of the United States, but that Congress can vest the appointment of inferior officers in the President, the heads of departments, or the lower federal courts. So there's a crucial distinction between officers and inferior officers, where only the President can appoint officers, but Congress has some discretion as to who would appoint inferior officers. And there's some recent Supreme Court cases where it found that individuals should be regarded as officers of the United States and invalidated statutes that gave the appointment power to anyone other than the President. And that's what sets up the issue this term in Kennedy versus Braidwood.
Okay, so the question addressed in Kennedy versus Braidwood Management was whether Congress properly delegated authority to the Secretary of HHS to appoint task force members to an advisory board. So Tara, can you help us understand what's at issue there?
Right, so the U.S. Preventative Services Task Force is the entity that's at issue here. And this is a group made up of about 16 researchers and medical experts who were supposed to provide information about the kinds of medical steps that would be wise to kind of prevent illness and disease. And for a while, this group was just providing advice and nothing more. But then the Affordable Care Act said, actually, if you designate a particular health measure as extremely useful and extremely important, we want businesses to cover their employees and provide these preventative services. And so it became a bigger deal. And the plaintiff here sued, saying, we don't like what this preventative task force is saying. We think it was unconstitutionally appointed. And while the litigation was going on, actually the power to appoint them was transferred to the Secretary of the Department of Health and Human Services. And the question then went up to the U.S. Supreme Court, is this appointment now okay?
Erwin, how did the court come down on the issue?
The Supreme Court says that this is permissible because these individuals are regarded as inferior officers of the United States. Since they are inferior officers of the United States, Congress can vest the appointment power in the Secretary of Health and Human Services. And the court went through analysis that explains it's the Secretary of Health and Human Services who oversees what they do, the Secretary of Health and Human Services that can remove what they do, and since they are inferior to this individual, the appointment power doesn't have to be vested in the President of the United States.
Okay. So Tara, how did the dissent see it differently?
So the dissenting opinion said first we should send this back to the Court of Appeals to answer the statutory question, does this statute actually allow the Secretary of the Department of Health and Human Services to appoint these folks? And then said, well, if we're not going to do that, we're going to say that we doubt that the statute actually gives the Secretary this authority. But the dissenting opinion itself was also fairly narrow in the way it analyzed this case. And I don't think that most folks would read this case and think that a lot is going to come out of it. I think there will be many more appointments clause challenges down the line. There are some pending right now. But I don't think this case dramatically changes the law in that area.
So what would you say the biggest takeaway from the case is then?
I think what it is that the Supreme Court has reaffirmed there is this distinction between officers and inferior officers. And I think the court takes a common sense approach to who's an inferior officer. If somebody can be fired by, say, the Secretary of Health and Human Services, that makes them inferior. If they had less power than that, that makes them inferior. The court still has not adopted a formal definition. It's a much more functional approach.
Erwin, there was also a case this term about removal, and it was on the emergency docket, Trump v. Wilcox. Can you tell us a little bit about that?
Sure. Terry, you were mentioning 1935 with the Non-delegation Doctrine. Well, in 1935, the Supreme Court decided another case, Humphrey's Executive versus the United States, where the Supreme Court held that Congress can create federal agencies, and Congress can provide that the members of those agencies can be fired only for cause defined in the statute. That case involved the Federal Trade Commission. The Supreme Court unanimously upheld the limit on removal power. But President Trump has said in executive orders and in declarations that he believes that Humphrey's executor is wrong, that it's a unitary executive, that the president should be able to fire anyone in the executive branch of government. In accord with that, he fired Gwen Wilcox, who's a commissioner on the National Labor Relations Board. She was appointed by President Biden, confirmed by the Senate. Her term goes to 2028. The National Labor Relations Act says she can be fired only for cause. President Trump fired her without any claim of cause. Kathy Harris is the chair of the Merit System Protection Board. She too has a term, and under the words of the statute, can be fired only for cause. President Trump fired her as well. The United States Court of Appeals for the District of Columbia Circuit in an en banc ruling said Humphrey's executor is the law. These individuals can be fired under the statutes only for cause. The Supreme Court, in a 6-3 ruling, reversed the D.C. Circuit, lifted the preliminary injunction issued by the district court, and in essence said that President Trump could fire these individuals during the time that the matter is being litigated. The majority opinion said that there is a substantial likelihood that the Trump administration will prevail on the merits. As Justice Kagan says, that's implicitly overruling Humphrey's executor in a case on the emergency. Now, of course, this doesn't overrule Humphrey's executor, but it sure provides a strong indication that a majority of the court, and is likely when the case comes to it on the merits, to overrule Humphrey's executor. Even though it's the emergency docket, I think it's a very important ruling.
Okay. Thank you, Erwin, and thank you, Tara. It was really great to have you both with us today.